right now, a 2024 split screen is playing out, and it's one we're going to see a lot of here in the coming months. On one side, President Biden set to campaign in an absolutely critical swing state, Michigan. Then on the other side, former President Trump in a federal courtroom for a critical hearing in his classified documents case.
Trump is trying to get those charges tossed, but so far the judge has expressed skepticism about some of his lawyers' arguments. The prosecution has also used the former president's own words against him. We have full team coverage with CNN Chief Legal Affairs Correspondent Paula Reed, CNN Senior Justice Correspondent Evan Perez, and at the courthouse, CNN Senior Crime and Justice Reporter Caitlin Polantz. Let's start there outside the courthouse. Caitlin, what is the latest out of this hearing?
Well, Boris and Brianna, this was a big, bold argument that Donald Trump's lawyers have been making in court, especially this afternoon, trying to tell the judge he had a lot of ability to claim the classified documents at the end of his presidency were personal, and that's the reason he took them to Mar-a-Lago. He should not be prosecuted for a crime. Judge Eileen Cannon already is expressing skepticism at that argument and an argument they made earlier today that the law is too vague around national security records. Just now, just a few moments ago, she told Trump's lawyers it's difficult to see how this gets you to the dismissal of an indictment. She also pointed out that perhaps some of the things that Donald Trump's lawyers are arguing today are the sort of things that you would have as a defense at trial, saying he didn't know he was taking the documents. He didn't willfully want to break the law in this situation. That might be a question for a jury. That's what the judge has been signaling so far. She also has said in court today that perhaps this Presidential Records Act pushback that Trump's team is making, saying that Trump should have so much latitude here to decide the records are his. Judge Cannon seems to be saying that that would allow future presidents to clearly say that a document is theirs when it's clearly the federal government's. That does not seem to be an argument that she's buying. The Justice Department has been making that to her as well, saying that these records that Trump had after the presidency at Mar-a-Lago are so sensitive that it put national security at risk. And they're the type of records that should never have been out of the hands and control of the security of the federal government. Boris and Brianna?
Caitlin, walk us through how prosecutors tried to undercut Trump's argument by actually quoting him.
They did. Earlier this morning, in the arguments, one of the things that prosecutor Jay Bratt brought up was what Trump was saying in Bedminster, New Jersey, after he left the presidency to people who didn't have the ability to look at classified documents, when he referred to and held up, waved around a piece of paper that was an apparent military plan from his time in government. Prosecutor Jay Bratt read from that transcript when Trump acknowledges that the record was classified and says to the crowd in front of him he wishes he could have declassified it and shared it more publicly, but he can't. Prosecutor Jay Bratt said in court today that that is the sort of thing that would show you he knew these weren't personal records. He also knew the law. And so these arguments that the Trump team is making today should not be able to get the case tossed. We're still going to wait to see what else the judge has to say. It's very likely she'll write some lengthy opinion on these motions and other motions Trump has made in court to try and get the case out from this courthouse. But we will see if she says anything more today that indicates which way she's leaning.
All right, we'll be looking for that. We know you'll be following it, Caitlin. And Paula, obviously, Trump's words have played such a key role in so many cases, from E. Jean Carroll, the case there, the Georgia election subversion case with the find the votes call. What about the factor it's going to be in this case?
It's such a big factor. That tape, that audio recording is such a critical piece of evidence. We broke the story that tape existed, and I remember talking to lawyers who were on his team at the time. They only found out that tape existed pretty late in the investigation because of witnesses who had gone into the grand jury. And I remember them telling me the existence of that tape changed the way they viewed the legal jeopardy that their client was facing. Because remember, at the time, he had all these varying explanations for declassifying, that he had a standing order to declassify things, that he could declassify things with his mind. But this recording undercuts all of that. It also, as the judge has to weigh now, really undercuts these arguments as well. So it is a critical piece of evidence.
And Evan, what are the implications of this argument that Trump deemed these personal matters. When you look at what was actually among these boxes, these are sensitive documents, right?
Right. I mean, we're talking about nuclear secrets. We're talking about the U.S. vulnerabilities to a foreign attack. What are the things that the U.S. would do in response to that? And as Paula just pointed out, I mean, that tape makes clear that he knows that these defense programs, these very sensitive defense programs, were still classified, and that he had not actually done some kind of blanket declassification order. And by the way, I mean, the idea of the limit of a president to be able to declassify things, it's not been tested really. And so, until that tape emerged, there was some question as to whether whether he had that power and what is the limit of that power. I think members of Congress and certainly in the Senate have said you can't just declassify nuclear secrets. It's not like that because of the way the government works. So the implications are huge if this judge sides with him on this.
Can you talk a little bit, Evan, about what the judge is saying here, that the arguments the Trump lawyers are making, that it's premature, this is something, she's leaning against them clearly in what she's saying. And can you explain why and where that leaves Trump?
Well, first of all, what it does is it sort of puts this onto a jury to make that decision. She's saying, look, this is not for me to make that decision. And to be honest, I mean, I'm kind of surprised that we're even having this hearing. She could have had these things briefed, and then she could have made a ruling and said this is something for a jury. But she's having this hearing where the former president doesn't have to even be there. He's choosing to do this. He also could be campaigning in Michigan if he wanted to. But she's giving him this opportunity. Every one of these hearings helps him delay this whole process. And so I think what she's saying is a jury will have to make that argument, make that decision, and this is an argument for you to present to the jury. Yeah,
she actually said to Trump's attorneys, quote, "It's difficult to see how this gets you to the dismissal of an indictment using the Presidential Records Act,
extraordinary
essentially
thing to do, right?
As an argument." What do you make of her seeming to oppose this motion?
I think they knew that, but really the number one priority right now is to delay this case until after this case and the other federal case until after the election, because if he is reelected, he can make both of these federal cases go away. He can have his attorney general dismiss the special counsel and the cases. So really their number one priority right now is delay. So even if she's willing to hear the arguments, they know they're unlikely to prevail on the merits. That for them is a win, because every day, every motion, every filing, that helps them push this back possibly until after the election.